Welcome to Leveraging Inspiration, the Inspired Patent Podcast. Adidas has a trademark strategy of suing early and suing often. In this episode, we will explore the advantages of this bold strategy. I'm Wayne Carroll, your host, here to share valuable insights, stories, and strategies for succeeding in intellectual property. Let's dive into the game of IP and learn how to win. This podcast is not legal advice, but is strictly educational and informational. Listening to this podcast or reading show notes does not establish an attorney-client relationship. Adidas has a very distinctive three-stripe logo, and looking at how they have worked to enforce that logo is interesting. So they have sued a lot of companies. One that became notable recently was when they sued Puma, which is a competitor of theirs. And Adidas and Puma were started by two German brothers, and who actually had a falling out and took their separate ways with separate companies, and have had this dispute ever since for more than 60 years. So not too long ago, back in 2017, Adidas sued Puma over a shoe that had 4 stripes that came from where 4 of the laces were and came down on the side of the shoe. So Adidas has constantly and regularly sued people if they believe they are using the 3 stripes or anything similar to the 3 stripes. Some of the example cases are them suing Walmart, suing a suit designer who they initially contacted him and said, hey, you're using 3 stripes. 3 stripes is us. Anything 3 stripes on clothing or anything is us. And so he went to 4 stripes on some suits and 2 stripes on other suits. And they still came back and sued him, and they took it to court. And in that one, they lost. Now, some people think, well, that doesn't sound like a very good strategy. But in trademarks, part of what I believe they're trying to do is make other people very aware of their trademark and aware of the risk. Even if someone gets close to their trademark and they sue them and lose, that person still has to endure a lawsuit over that. Now, the Adidas and Puma trademark infringement lawsuit, I found a bunch in the news when it was filed, but I couldn't find anything of how it was ended. 2 months after it was filed, it was dismissed. Clearly, there was a settlement that must have taken place. So, and that often happens. So when you have a strong trademark and you want to keep it strong, it is important to monitor it and watch for anybody using it. Large companies like to take strategies in having watch services or services that are scanning the internet, looking for their name or their symbol and cross-checking it with the company's own database of here's where it should be used and everywhere else it shouldn't be used. And then they often send cease and desist letters. There's actually some good software companies that what they do is they interface with Amazon and other companies to tag and notify Amazon when there's something that the company believes is infringing. For large brands, this can be thousands of listings a month. And so having a whole service. Now, for small and medium businesses, it often makes more sense to review manually on a weekly or monthly basis to see if there's anything that comes up. There are watch services that are reasonably priced for the small and medium-sized businesses to especially catch when somebody files a trademark that is similar to your trademark. And this is part of, a small business isn't going to be able to sue dozens of people in a decade. That's pretty expensive. A large company can handle that, and it's still going to be a expensive and drain on them. But in some cases, Adidas has actually been able to get some large settlements or not just settlements, but judgments. There was one in 2008 where Payless Shoe Source was ordered to pay $304 million. And of course, these things get appealed and up and down, and it later got reduced to $64 million. But that's still, it's going to scare other companies off of being aware. Okay, don't put 3 stripes on shoes, and be careful if you're going to put it on other clothing, because Adidas doesn't just sell shoes. And so Adidas 3 stripes, they actively enforce their trademark. They make sure it's distinctive. When you're choosing a trademark, you want to consider, now 3 stripes, it's very basic, simple logo. And so it's, if you have a complicated logo, it's going to be harder for people to recognize, harder to do in very basic formats like black and white, but it's going to be more distinctive, and people are less likely going to accidentally use it. But with something like 3 stripes, that is something that an amateur designer who isn't aware of what's going on in the fashion world with trademarks may decide to put 3 stripes because he's seen other shoes with 3 stripes. Or, companies may try to get away with making something kind of similar. And the best way to make sure that doesn't happen is to enforce vigorously your trademarks. Unfortunately, that does sometimes mean taking people to court. Some of the strategies are when there's an infringement, the question is, when do you sue? And some companies have the strategy of, if there's an infringement, we're going to get a lawsuit filed, and then we'll tell somebody about it. What this does is, if you're willing to sue and you're willing to really put a strong foot forward, you can file a lawsuit. That way it's in your home court, the one that works for you. And then when you serve them notice, you say, there's already a lawsuit here. Maybe we can settle this. But if not, if we're going forward in the court we want. And if the opponent doesn't want that, they might be able to petition the court and say, it doesn't make sense to have this case here. It's too burdensome on us. They might win or they might lose that. But even if they lose, they've still got to go forward with a lawsuit, because it'll be transferred to their court, whatever they say. If the court rules that, yes, you can be sued in your court and this one doesn't make sense, it's not fair to make you come to this court. But a lot of times when you're selling nationally, it is very possible to get someone to have to appear in any court nationally, because if they have offices and established in multiple parts of the country. Before you use a brand or a logo, you definitely want to have a search to clear it. One thing that's very discouraging is when a company starts using a trademark and they've used it for several years, and then they go to register it and discover it's really close to what somebody else has done. Sometimes they file a registration without a research, and at the current time in 2023, it's taking about 10 months just for the trademark office to look at and give you their initial response of, is there a problem with this trademark? So if you have a trademark and you start using it and you file the trademark registration, You won't know if the trademark office thinks there's a problem for 10 months. And you can be investing in your brand during that whole time and not realize that you've got that problem. So establishing a trademark, it really makes sense, especially with the trademark office being so backed up, to have research done ahead of time to get a good idea of, are you going to be successful in getting this registered? And some companies will file a trademark before they use it, wait until the trademark office approves it, and then start using the trademark. But that's a very long-term strategy now that it's going to take 10 months for the trademark office to give a thumbs up or a thumbs down on that. The purpose of trademarks is to distinguish your company. When you pick a trademark, you want to make sure that it distinguishes your company from others. And that is what Adidas has been doing with their 3 stripes logo. If they allow other people to start using 3 stripes, then they lose that distinctiveness. And then it's harder for them to win. And it's kind of a downward cycle. So for many companies, especially where the trademark is such a big, important part of the value of their company, it makes sense to be very vigorous about the trademark and to not let others come close to it at all. Sometimes that means suing people that are maybe too far out, like a high-end suit company isn't necessarily going to be confused with sporting goods. That's what a jury decided, that suits and sporting clothes and him using 2 or 4 stripes was not going to be confused with Adidas's 3 stripes. But they would rather try and test to see, can we enforce that far? And if they can't, well, now they know what the limit is, and they're going to aggressively go up to that limit and keep people away from those 3 stripes. That's what it takes to have a strong strategy. And as I've said in a prior podcast, one of the best defenses for your trademark is a strong offense. Thank you for joining me. I'm Wayne Carroll, and this is Leveraging Inspiration.
Areas of progress. So, for instance, there is now an agreement to phase out internal combustion engines by 2035.